Attorney, the Royal Commission into Institutional Responses to Child Sexual Assault has recommended that Catholic priests hearing confessions be legally obliged to report admissions made to them about child sexual assault. Will you legislate, or will your government legislate to implement that recommendation?
Thank you, Mr. Searle. So about a week or so ago, the New South Wales Government issued a discussion paper to elicit stakeholder feedback on the various recommendations of the Commonwealth Royal Commission, one of which concerned confessionals of Catholic priests, or indeed any priest that takes a confession. We will be considering those recommendations very closely. We'll be eliciting feedback from all relevant stakeholders, and once we've done that, we'll come forward with a package. But I won't preempt at this stage what might be the outcome of that consultation from that discussion paper.
What is the time frame that you envisage for these steps to be taken?
I would envisage that we would be looking at legislation in the budget session of next year.
Okay.
That's not a promise or an undertaking, but that's my best expectation at the moment.
I understood that was the position. Attorney, you've had a lot of notice of this issue coming up. In fact, in answers to questions on notice about Section 316 of the Crimes Act, lodged by the Shadow Attorney, specifically referred in your response to the Royal Commission review. So you knew this issue was coming. Why weren't you able to do that consultation around this issue in advance of the Royal Commission recommendation?
Well, look, I think
it's not a new issue.
These are incredibly sensitive issues. The issue you just raised, on the one hand, you have the Catholic Church, which regards it as fundamental that the confidentiality of the confession is respected. On the other hand, you have a terrible legacy of institutional abuse in many institutions, including the Catholic Church, and the understandable view of victims and victim advocacy groups that confidentiality can, in the circumstances, no longer be upheld. I think it's important for the New South Wales Government, which incidentally is the first state or territory government in Australia to respond to the Royal Commission, that we understand all the views of all stakeholders and get the right decision.
Section 316 of the Crimes Act requires the consent of the attorney before certain categories, including the clergy, can be prosecuted for failing to disclose a serious indictable offence. In your short time as attorney, have you ever been called on to exercise that discretion?
Not that I can recall, no.
In what circumstances would you grant or withhold consent? Is there a policy by which the attorney informs himself of these matters?
Look, it hasn't come across my desk, so I certainly haven't formulated such a policy. Whether previous Attorneys General have formulated some guidelines or policies, I'm not aware.
Is your departmental secretary aware?
No.
No, you're not aware, or there is no policy?
There's no current policy in place on this matter.
Okay. Does the fact that the disclosure was made in a confessional mean that you would automatically refuse consent to a prosecution for withholding that disclosure, or how would you go about exercising that?
Well, look, that's
happy for you to take it on notice.
Well, look, no, I'll answer it this way. At the moment, that's hypothetical because no such application or issue has come across my desk. Mm-hmm. If and when it were to do so, well, then obviously it is something I'd give careful consideration to.
Okay, well, perhaps I could ask through you to the Secretary, has that discretion been exercised by previous attorneys over the last 2 years?
Not to my knowledge.
Okay. Attorney, in your comments in reply to the second reading debate on the Justice Legislation Amendment Bill, you appeared to be attacking or at least questioning the notion of specialist courts, at least in some circumstances. Is that attitude the reason why you won't fund the Downing drug court properly or expand it to Dubbo or Tamworth?
Could you repeat the question, please?
Well, I'm asking why you haven't funded or won't fund the Downing Centre drug court properly or expand that operation to Dubbo or Tamworth.
So you're not asking me about my comments in the second reading speech and reply, but rather a standalone question about funding the drug court.
Well, I'm just wondering whether the views that you expressed in your reply are the reason why you won't fund these measures, because you have queries or reservations about so-called specialist courts.
No, in reply, I think this is what you're referring to. I quoted from His Honour the Chief Justice
Yes, that's the one.
About some remarks that he made at the Pacific Judicial Conference, where he observed that specialist courts run the risk of creating insularity, jurisdictional overlap and fragmentation. There is a risk that specialised courts will evolve into a kind of archipelago of islands of expertise separated by a sea of unknowing.
Yes, I
in invoking those comments, I wasn't suggesting some absolute or invariable rule that we shouldn't be looking at specialist courts, but rather to observe that you should approach that very carefully and cautiously, lest the problems that His Honour identified emerge. That said, in the case of the drug court, we know that the drug court that we have at the moment, principally at Parramatta, but also in the city and at Toronto, appears to work pretty well.
It does.
We know from a Boxar analysis back in 2007 that those who go through that process appear to have a lower rate of reoffending than others. That said, I don't understand that that Boxar analysis involved a cost-benefit analysis of a separate drug court. In other words, it certainly identified the efficacy and the benefits of a standalone drug court, with not just the legal process involved, but counsellors, drug treatment programs and others. Certainly, I am interested in whether or not we can expand the operation of the drug court, and when I can, I'll be considering any possible expansion, e.g. in Dubbo.
Okay. The Downing Centre Drug Court is restricted only to defendants who live within the boundaries of the City of Sydney, and it's, I think, restricted to about 40 participants at any one time. Now, given the undoubted need for that kind of service, isn't that restrictive nature a bit absurd, and isn't the case for expansion, given those positive outcomes, overwhelming?
Well, I think you have to look at that in this context. It's not as if an accused doesn't go through the drug court, that they're otherwise dealt with in some sterile, legalistic way. There are other things we do. We have, for example, invested $197 million on drug and alcohol services, including prevention and harm reduction programs across New South Wales. Commonly, those who are dealt with by the judicial system and have a drug and alcohol problem will be put into diversionary programs like the Merit Scheme. So the drug court is one way of approaching a drug and alcohol problem of accused, of offenders, but it is not the only way of doing so.
No, but as you indicated, the evidence to date shows that it does have a good set of outcomes, and in many respects better than the general criminal justice system. So what kind of indicia or evidence would you be looking for to be persuaded of the need to expand it to places like Dubbo, Tamworth, Wollongong? Places where there is also undoubted need.
As I said before, you have to look at not only the benefit of a drug court compared with some other approach, but also the cost of doing so. It is an intensive approach in terms of the physical resources you need. You don't just need a courtroom. It is an intensive approach in terms of the professionals that you get involved, drug and alcohol counsellors and so on. So in weighing up any decision to expand the drug court, the government would take account of those factors, but also look at the efficacy of current programs like the Merit program I referred to, which is the Magistrates Early Referral into Treatment program, which deals with, among others, offenders with drug problems who are eligible for bail, and helps them address drug problems that may contribute to their criminal behaviour. And their progress in treatment is something that, under that scheme, can be considered during final hearing and sentence.
What discussions, if any, have you had with the member for Dubbo about the drug court opening in Dubbo?
Look, the member for Dubbo is certainly a very vocal and strong advocate for his community on many fronts, and I understand he's quite supportive of at least some sort of pilot of a drug court in Dubbo.
Yeah. And have you had any discussions with a member for Tamworth about opening a drug court in Tamworth?
I may have, but I can't recall at the moment.
Okay. Do you recall if you've had any other discussions with any of your other parliamentary colleagues about drug courts?
I'd have to take that on notice.
Happy for you to do so. The government's had a proposition before it for over a year from the district court to establish a Koori court.
Yes.
When do you envisage responding, and what's causing the delay?
Well, look, I had a proposal from the Chief Judge in relation to that. There is, of course, a youth Koori court in Parramatta, part of the Children's Court, and what the Chief Judge has proposed is a hybrid between how that youth Koori court operates on the one hand and the drug court on the other hand. So it's not just looking at a specialist way of proceeding between a guilty plea and sentence, but also judicial intervention post-sentence. So we're considering that proposal at the moment. I've discussed it with the Chief Judge. I've also discussed it with Judge Yahia, who is quite a vocal advocate for that from the District Court, and I've had a discussion with the Bar Association about it as well. We are looking to evaluate that proposal and see whether it can be piloted. I can't put a definitive time frame on when that might be, but my intention at the moment is to make a decision in time for the next financial year.
Okay, and from what you've said, I don't want to put words in your mouth, but do I understand that your view is generally a positive one, subject to...
Look. In principle, I can certainly see the merits of that approach. The Youth Koori Court, we haven't yet had a formal evaluation back from Western Sydney University on that, but all the indications from stakeholders are fairly positive. It's pretty positive. In terms of engaging the Indigenous community in the judicial process, that they can feel some confidence in what happens. So look, I am very interested in the proposal, and hopefully we'll be able to make a decision in the first half of next year.
Okay. Now, in response to that evaluation, do you have a time frame when you might expect to receive it? I'm happy for you to take
I'll take it on
notice.
notice.
These are not questions.
No. I look imminently is my understanding.
Okay. Now, with the Koori Court in the Children's Court at Parramatta, Judge Johnson, as I understand it, has developed that process himself using the existing resources of his court. What additional assistance, if any, has your government provided to that Children's Court?
Well, among other things, we provided, in June 2017, I announced a $220,000 funding boost for Marist Youth Care to assist young Aboriginal offenders who appear before the Youth Koori Court. But I don't understand, I'll withdraw that. It is funded from Children's Court resources, but I don't understand there is any problem or issue with that.
Okay. Your government referred the issue of a statutory cause of action for serious invasions of privacy to a COAG working group, and at the October meeting of that council, a working party led by New South Wales was established, but there was no reference to that idea in the communique of the council's last meeting, which I think was in May. Does that mean that proposal or that reference from New South Wales is now dead at a national level?
Look, I don't know that it's dead, but
it's not very healthy.
my perception is that there doesn't seem to be a lot of enthusiasm from other jurisdictions for it.
In fact, it's only South Australia and Tasmania who exhibited any interest apart from New South Wales, is that correct?
Look, I can't recall precisely which jurisdictions.
Did you take that on notice?
I could take that on notice, but I accept the general proposition that support was underwhelming.
Now, that reference, it was just an effort by your government to kill that idea off, wasn't it, just by kicking it into touch?
Not at all. So look, I think that reference preceded my appointment as Attorney General, but we don't refer things to COAG with the intention of kicking them into touch. We aim to score goals, but it's a team effort. If you've only got a couple of players on the field, you don't necessarily get a try or a goal depending on your football code.
Well, given that the prospects for a national scheme now appear to not be very healthy. Will you now support the findings of 2 Law Reform Commission reports and the unanimous report of a New South Wales Parliamentary Committee and introduce a statutory cause of action for serious breaches of privacy here in New South Wales?
Well, I think the view that was taken before I became Attorney-General by the government was that if there were to be such a statutory cause of action, it ought to be a national or a federal one, or a uniform rather than New South Wales going it alone. But I'm happy to take that question on notice.
Yeah. Well, what the government has done is to introduce legislation, in a sense, creating a criminal offence. So that's a sort of a pretty serious step to take, and the opposition supported that.
You're referring to Intimate Images?
Yeah, the Intimate Images
yes.
Legislation. So in one sense, you haven't waited for a national scheme there. So you're obviously convinced that some kind of action was required. So why the differential for a civil cause of action?
There are guidelines for state and territory laws in that respect that were agreed at the Law, Crime and Community Safety Council meeting back in May, I think. So we didn't jump the gun and go ahead unilaterally with our own legislation. We waited until there was a consensus across jurisdictions about the framework within which each state or territory would legislate, and then once that framework was agreed, within a couple of days we announced what we were doing.
Now, one of the features of that legislation is that post-conviction there is a sort of a statutory power to sort of take down the offending material, but in a sense that's really the cart before the horse. That's like a long way after the damage has been done. The unanimous recommendation of the parliamentary inquiry here suggested that that is actually a really key feature, to be able to intervene early and swiftly without putting a victim through all the trauma of any kind of legal proceeding to take that material down. Now, your package hasn't done that. Will you at least revisit that one aspect?
Well, the package does include takedown powers where a court can order an offender to take reasonable steps to get material taken down. The difficulties are these. If material is on the internet, and it is not just in New South Wales, it could be, in effect, in one view, it's you can see it anywhere in the world. The service provider, the host computer may be anywhere in the world. Those sorts of issues are best dealt with at a national level.
Sure, and we're the offenders here in New South Wales, Mr. Attorney, that's subject to court orders here.
As you probably know, the Commonwealth has announced that it's looking at its own civil penalties and related regime, and we expect that those takedown powers will be dealt with in Commonwealth legislation. And it is best done on a national level rather than a piecemeal approach.
Sure, and I think we can all agree that national action is desirable where you can get the agreement to do so. But does that mean it's the view of you as attorney or your government that where you can't secure that sort of national consensus, you're just going to put it into the too hard basket?
No, look, my expectation is there will be national laws that will deal with this, and therefore there won't be a gap that has to be filled. But certainly, if contrary to my confident expectation that will not to happen, I'd certainly revisit it.
Yeah. Okay. Mr. Attorney, I understand there's no provision in the legislation which allows for a Justice of the Peace whose appointment has lapsed to be reappointed, even if the lapse is due to an error by the department. Is that correct?
Mr. Cappy knows the answer.
I'll have to check the technicalities on that one, so I'm afraid I have to take that one on that.
Okay, so as I understand the process, when someone's appointment comes up for renewal, the department sends them some paperwork, but where the department fails to do so and the appointment lapses, they have to sort of, as it were, go back to the bottom of the deck, do they, and apply from scratch?
We've introduced a number of online capabilities, including the capacity to seek reappointment online, so obviating the need for us sending out additional paperwork, so that enhancements that we've brought into play recently should overcome some of these constraints.
Okay, I have a case of a person who was a JP for some decades whose appointment lapsed due to an error an admitted error by your department, if I provide you with the details, are you happy to look into that to see whether or not it can be remedied?
You didn't have to wait till budget estimates to do that one, surely.
Well, it was a good opportunity.
Good approach.
Attorney, just returning to Section 316 and the discussion paper and the Child Abuse Royal Commission recommendations, does your discussion paper specifically canvass the issue of the confessional?
Not in terms.
Well, then how is that responsive to
Well,
the
it is.
Commission
It is because
recommendations?
the question is whether there's an obligation to report, and whether that obligation to report will override any privilege or confidence that attaches to the confessional.
Okay, so you see it in that context,
Absolutely.
even though it doesn't specifically.
Look, I don't recall the discussion paper. Look, I may or may not. I don't recall it using the word confessional. But it's pretty clear, and from public discussion, everyone understands what we're getting at. A question will be raised as to whether a duty to report will override any confidence or privilege attaching to a confession.
Attorney, your predecessor, Ms Upton, told a Jewish Board of Deputies event in October 2015 that Section 20 capital D of the Anti-Discrimination Act wasn't working and must be changed, as no prosecutions have been brought since it was created. She wasn't able to deal with that in her term as attorney, but will you act on the well-recognised shortcomings of Section 20 capital D, given there's been a parliamentary report and the opposition's brought forward private members' bills?
Unanimous recommendations of the Law and Justice Committee.
Yeah, I acknowledge that interjection.
Well,
We're both on it, yeah.
I'm aware of those recommendations. We have, since I became Attorney General, been consulting very broadly. I had Dr. Kirkasharian consult, don't hold me to this figure, but it might have been something like 40 community groups on Section 20D. And indeed its analogues in the Anti-Discrimination Act in relation to other forms of discrimination. I have met the Jewish Board of Deputies. I've met the Gay and Lesbian Rights Lobby. I've met the Catholic Archbishop. I met an Orthodox minister this week. We want to make sure that we get this right. It is an incredibly sensitive area. We want to get the balance right between protecting community safety and cohesion on the one hand and freedom of speech on the other hand.